All right. Good evening, everyone. How's everyone doing today? Hello, hello, hello. Um, my name is Ifeoma Odunlami, immigration attorney from the Odunlami law firm here in Cedar Knolls, New Jersey. Um, I have a wonderful topic. Let's get into it. I'm going to wait for people to join. And remember, when I finish the topic, please post your questions, your comments, and I'm happy to answer the questions as much as I can. I hope everyone's doing great. It's Thursday, getting close to the weekend, and I'm excited. Time to rest so that we can regroup and be ready again on Monday to do the things we love doing, which is helping fellow immigrants get legal status so that they can live in the United States without fear of deportation, without fear of family separation, so that they can contribute meaningfully to this great country. Okay, that's what we love to do. So I see someone asked a question, do we need to file a police complaint for VAWA? Good. This is what I'm talking about today, VAWA. So log on in, send the link to people who might be interested, and even people that may not be interested, because you just never know. So let me introduce myself to people who are just joining in, people who are joining for the first time. As I said before, my name is Ifeoma Odunlami. I'm an immigration attorney at the Odunlami law firm. Although we are located in New Jersey, we service clients in all 50 states. Many of our clients get their green card without ever seeing us in person, so your location is not a problem. So today I want to talk about VAWA. I haven't talked about VAWA in such a long time, but I want to talk about it today because guess what? VAWA is 30 years old. So 30 years ago in 1994, the current President Biden authored the Violence Against Women's Act legislation. It was signed into law by President Clinton. And so VAWA is here to stay. It's here for a reason, to help people who have been abused either or treated with extreme cruelty in their by their immediate relatives who are U.S. citizens or green card holders. So VAWA is a lifeline for a lot of people. It empowers them. It allows them to get their green cards on their own without relying on their immediate relatives. And one of the reasons, or one of the advantages of VAWA in immigration is that Congress realized that it would be really weird to have somebody who was your abuser be also responsible for getting you legal status. Basically, it gives that person a lot of power, right? And that's what abuse is about, power and control. So with VAWA, you basically have the power put back in your hands, the power to move along with your petition without having to rely on somebody who is abusive. So today I want to talk about VAWA denials. A lot of people are applying for VAWA. A lot of our cases are getting denied. And I want to talk about that. I want to give you guys some understanding of what USS is looking for in VAWA cases so that you don't run the risk of having your VAWA case denied. So to start, because there's somebody who's going to ask me, what is VAWA? VAWA stands for Violence Against Women's Act. It applies to men. So even though it says women, it really doesn't apply. I wish they would change the name because honestly, I think it's a little confusing. So VAWA applies to men, it applies to women, applies to children, applies to parents. So if you're married to a U.S. citizen or a green card holder and you're in an abusive relationship, it could be physical abuse or it could be extreme cruelty, which does not have to be physical abuse, right? You can file for VAWA. If you're the child of a U.S. citizen under the age of 21, U.S. citizen or green card holder under the age of 21, and you're being abused, you can file for VAWA. Now, remember that the definition of child encompasses stepchildren, which means that the parents in that qualifying relationship got married before that child turned 18. So in that case, if there's abuse, they can file for VAWA. If you're a parent of a U.S. citizen, adult U.S. citizen, which is 21 and above, and that child, which is also called a son or daughter, has been abusive towards you, you can file VAWA. All right. And if you're the parent of a child that's been abused, you can also file VAWA. So it's important to understand that VAWA is what VAWA does, right? And how it allows you to get your green card on your own. So if you file the I-360, and also if you want to file the adjustment of status, which you can file those together, and then you can, wait to get your green card. So typically what happens is the I-360 is approved first, and then you get information for either an interview for your I-485, the adjustment of status, or you just get your green card in the mail. Now, you may not be able to file for adjustment of status for many reasons. Maybe you're in deportation proceedings, so you cannot file an adjustment of status, or maybe you're inadmissible for one reason or the other that makes it impossible for you to file adjustment of status. In that case, you would file VAWA alone, the I-360 alone, and at the end of the case, if the VAWA is approved, you get a work permit. You may not be able to get your green card because you didn't file adjustment of status, but you get a work permit that is renewable every year. So let's talk about the reasons that many VAWA cases are getting denied. And a lot of people come to my office with VAWA denials. That's the reason why I want to talk about this. Number one is you want a qualification. If you need to be able to prove that you're married to, in the case of married, that you're married to a U.S. citizen or green card holder, right? Or your parent is a U.S. citizen or green card holder, or your child, or child over 21 who you're filing the VAWA against is a U.S. citizen. Remember, for the parent, only a parent with a U.S. citizen child can file VAWA. So if your child is a green card holder, you cannot file VAWA, which kind of makes sense because legal green card holders cannot file for their parents. So I guess it's like the same kind of thing, right? So you have to be able to prove the qualifying relationship. So if you don't prove the qualifying relationship, either by getting information, a birth certificate to show that this is your parent, or the marriage certificate to show that you're actually married to this person and that your prior divorces were properly terminated, then that's one big reason why people's VAWAs are getting denied. And this is the thing, right? VAWA takes a long time, 2.5 to 3.5 years. So you don't want to put in all the effort, all the work, all the expense of filing VAWA only to find out at the end of 2.5 years that you didn't do something right and you didn't qualify for VAWA. And that could be a problem actually, because sometimes in many cases, you may not be able to refile a new VAWA, right? So that's why it's important to get it done the first time, get it done right. So let's talk about divorce decrees. That's a big thing, right? Because a lot of cases are getting denied because the beneficiary, that's the person, intending immigrant, was married before and got divorced, then married a U.S. citizen or green card holder, and USCIS found that divorce, the initial divorce or one of the divorces in the past, was not properly terminated. So what that means is this: if your divorce is not properly done, if that marriage is not properly terminated, then your subsequent marriage to a U.S. citizen is void, never existed. It's not recognized. So that's why it's important. I keep saying this, right? If you are in the United States at the time your relationship to another person, maybe in your country or in the United States, terminates, file a divorce from here. You can file a divorce from the United States for where your ex is abroad. If your partner or spouse is here, there's really no reason for you to file a divorce in your country. Because I think the thing is, people have been told that USCIS will not recognize the divorce that is that's filed here because the marriage took place in their country. That's not true. That's not true. Get you a family lawyer. And I always say this, before you do anything, that could impact your case, talk to the lawyer that handles the aspect of your case you're working with. So if you're looking to file a divorce, look for a lawyer that knows what they're doing. Don't go to the notario or to the person that helped your cousin's wife or that, because that's how people get into trouble. So making sure that your divorce is properly done is important. If you have a spouse that, if you were the person who was a defendant in a divorce case where your ex-spouse divorced you and you're not sure if what they did, take the time to properly authenticate that divorce before you get married. I had a case where this potential client came to my office and he had been abused in his relationship. As a matter of fact, his wife, the abusive wife, went to jail because she stabbed him. And he filed VAWA, and the VAWA was denied because his prior marriage, the divorce from the prior marriage was not properly done. So USCIS did not approve that VAWA case. Of course, he might be able to do a U visa as a victim of a crime. Yes, that was available to him, but that's not always available to everyone because U visa has special requirements. So it's important for you in a marriage to make sure that when you're getting married to your U.S. citizen or green card holder spouse, that all your prior marriages have been terminated properly. And even if you get a green card, I always say this, you get a green card, sometimes you get a conditional green card, or even get a 10-year green card and you're going for naturalization. USCIS can go back again and look at that prior divorce. Maybe they didn't catch it the first time and they catch it the next time before your naturalization or before removal of your conditions. They will still they will deny you your 10-year green card, deny you your naturalization based on that. So this is how important it is. You don't feel that you're okay unless you become a U.S. citizen. So a lot of people don't realize that the divorces were not properly done. So take it upon yourself to go back and check on your divorce decree before you get married to a U.S. citizen or green card holder. Now, there's an exception for people who, if you're married to a United States citizen or a green card holder who was married, and you find out that their marriage was not their divorce was not properly terminated before they married you, there's something called the bigamy exception. So the bigamy exception allows you to proceed with your VAWA case, even though that marriage is technically void because the U.S. citizen or green card holder who is, the abuser, did not properly terminate their divorce, their marriage. So that works for a bigamy exception, but it doesn't work when you, the intended immigrant, didn't have a properly terminated marriage. All right. So let's talk about living together. There's a requirement by USCIS that you must have lived together with your abuser at some point, and you have to have proof of it, right? So there's no requirement that you have to have lived with them for a day or a year. There's no requirement with regard to the amount of time that you have resided together. So it can be as little as 1 day. It can be as long as 1 year. Nobody cares. But the important thing is you have to have proof that you actually live together. And that proof comes in the form of a lease or affidavits from your neighbors or from the landlord, or showing documents that show that both of you have had the same residence at some point. So now the funny thing about VAWA is sometimes it's really hard to provide evidence because the nature of the abuse is such that the abuser might withhold evidence. So that's the reason that the burden of proof, the standard for proving a VAWA case is any credible evidence. And that's why when we do VAWA cases, we have to always think outside the box. We're looking for evidence. We're searching for evidence in unlikely places for our clients, because sometimes the abuser has not given them the information they need to be able to prove their case. All right. And that's the reason why it's important to, go with somebody who specializes in VAWA. Because I've heard people come to my office tell me that they went to see a lawyer. The lawyer said they cannot file a VAWA case because they don't have a police report. They don't have a hospital report. That's nonsense. Most of our cases, I can tell you, we don't have a police report. We don't have a hospital report. And more importantly, there's no requirement in the law that you have a police report or you have a hospital report. All right, or that you must have been physically abused, because abuse can be emotional. It can be psychological, it can be financial, it can be verbal, and it could be one or a combination of just little, abuses that together form a pattern of extremely cruel behavior. All right. So, Mohammed says, can a green card holder file for spouse who is legal status? I don't know what that means, but I think what you're asking is, can a green card holder file? Okay, I think you're saying, can a green card holder file for a spouse who has legal status? Of course, yes. A green card holder can file for a spouse who has legal status. Hi, Teresa. How are you? Therese, sorry. Therese wants to know what, you know what, I think I'm going to wait until I answer questions, because some of you are asking me questions outside VAWA, and I want to come up and answer those questions. So I'm going to finish with my VAWA, my VAWA presentation. So let's talk about another reason why your cases are being denied, right? If you don't abide by the deadlines. In VAWA, there are certain deadlines. Number one, if you get divorced from your spouse, you must file your VAWA within 2 years of the divorce. If your abusive spouse dies, you have to file the VAWA within 2 years of the death of the abuser. If you are a child, a stepchild, or child, right, a stepchild, right, and you have a VAWA case, you must file that case before you turn 21. And for you to be a stepchild, for you to qualify to file for VAWA as a stepchild, you have to show that the step relationship between your parent and the other parent happened before you turn 18, not on your 18th birthday. You cannot have been 18 at the time that marriage took place. And if for some reason you're not able to file the VAWA as a child before you're 21, and that reason has to do with the abuse you suffered, the law gives you additional time until you're 25. So if you've missed the 21-year, the cutoff at 21, reach out to a lawyer and let them see if you have that additional 4 years to file your VAWA application. All right. No, Therese, that's okay. It's not. I'm going to answer it. Don't be sorry. It's okay. I'm going to answer it, but I want to have some, I guess, continuity. So when I finish my my presentation, I'll go and answer all the questions. Okay. So. So somebody says, can a person get VAWA if they were abused by a family member? It has to be an immediate relative, like I talked about, the spouse, parent, or child. Okay. Now let's talk about another reason why people's VAWA petitions are getting divorced: a lack of a bona fide marriage, a lack of evidence of a bona fide marriage. Now, in the marriage situation, which most of the questions are going to be about, you have to prove that it was a bona fide marriage, that you entered into this marriage because you wanted to be with this person and not solely to get immigration benefits. So I've seen a lot of people tell me, oh, their spouse didn't show up for the interview, therefore I'm going to file VAWA. It's not automatic. You have to prove that that relationship was bona fide. It was a real marriage. Because a lot of people are making up money off of you, telling you, oh, well, they didn't show up, therefore file VAWA. But if you had a contractual relationship where you paid that person to get married to you, you can't file VAWA, because VAWA requires that you marry that person in good faith. So the starting off point, right, was it a bona fide marriage? Can you prove that you and this person got married for the right reasons, which is you wanted to build a life together? And there are ways to prove that. You can show that, sometimes you can even go back to your dating era, how long you guys dated, the things you did when you were dating, or the fact that you lived together, you shared a life together, you had financial resources together, people knew you as a couple, you went on vacation together, you did things together. And a lot of people think that, just having a joint bank account, or we file taxes together, we have insurance together, that's not enough, because the USCIS officer is looking at the totality of your evidence. So yes, if you don't have that evidence, they dig a little deeper. But just because you have that doesn't mean that it's a bona fide marriage. USCIS will search, and sometimes they do the fraud investigation to make sure that it's a real marriage. So that's the starting point. If you go to somebody and they tell you, oh, file VAWA, without asking you and digging deep to make sure it's a bona fide marriage, that person is just there to take your money. Because the truth of the matter is, whether or not they win the VAWA case, some people don't really care. They take your money and you're on your own, and that's not fair. So make sure that whoever is working on your case is somebody who is invested in helping you get your papers properly. All right? Because if you don't qualify for VAWA, you may qualify for something else. We've had people who didn't qualify for VAWA but qualified for T visa, qualified for U visa. There are other things you may qualify for, and you want to find what you qualify for so that you have a great chance of getting your case approved. All right? So having a bona fide marriage and having proof of it is really important. And again, of course, in the VAWA setting, sometimes it's hard to have the proof. And that's why your declaration is really important. Sometimes cases are won on just the declaration because the nature of the abuse can be such that those documents that you need, you don't have them because the abuser won't give you access to them. All right? Sometimes you have abusers that won't open a joint account or won't put you on the lease, or, you know, they do that kind of stuff, you know. So yeah, sometimes you may not have it, and sometimes you have to think outside the box. We had a client who had absolutely no evidence, and we said, looking around, we went onto their social media, and guess what? They had so many pictures on social media of them and their spouse, which they didn't think was evidence. You know, they had text messages. They had, you know, they actually had friends who had taken pictures of them at gatherings, which they didn't have the picture because the abuser broke their phone. So sometimes you're going to have to think outside the box. You know, maybe you have friends that you went on certain functions with that took pictures, and they may be able to share those with you. Okay. So another reason why people get denied on their VAWA cases when they have a weak declaration. Your declaration makes no sense. It's not credible. It conflicts with everything else you've submitted. It conflicts with the things you wrote in the forms you completed. So if your declaration is not credible, you're likely going to have your VAWA case denied. All right. So another reason why people get their VAWA case denied is when they get married while the VAWA is pending. Guys, please, you cannot do all this work to lose your VAWA case because you abandoned it due to getting married before the VAWA was approved. All right. You can have children, but stay single. All right. Don't think you can outsmart USCIS. Don't say, how are they going to know? Don't do it. Period. Don't do it. Okay. So, I get this question a lot, right? You're in a VAWA, you have a VAWA case, it's pending, and then you meet somebody else who you love who wants to file for you. And then the question is, well, should I abandon my VAWA case and have my new love interest marry me and then file? So what I'm going to say is, this is a really personal question, and you have to make a determination of what you want to do. But I believe that the best power you have is the power that rests on you, because you really cannot trust that somebody else is not going to do something that will, you know, that will spoil your ability to get your green card. You cannot vouch that somebody else is going to be there for the long haul, because relationships are just very complex. So if you can go through your VAWA, get your VAWA petition approved, then go ahead and marry the person, because relying on yourself is more, I'd say that's a better way to go than relying on human beings who are just fallible. So another reason why people are getting denied, their VAWA case are getting denied, is that they have no proof of good moral character. Now, this is not a complex one, right? Proof of good character means you need to get a police clearance or FBI report that shows that the cutoff time is 3 years from the time you file the VAWA. So if you live abroad, make sure you're getting a police clearance. Sorry, if you came to the United States and within those 3 years you had time when you lived abroad, you have to get a police clearance from where you stayed for longer than, I think it's 6 months. Anywhere you've lived for longer than 6 months in the 3 years preceding filing, you have to get some form of police clearance. Okay, right? Yeah. Okay, and you can also get affidavits from people that know you're a good person. They can write you affidavits. If you've worked in your church or you've done some kind of community service, they can write you, they can write affidavits showing that you're a person of good moral character. And if in the event you have made mistakes in your life, you may be able to still get VAWA if it's something that you can get forgiven, because you would need to file a waiver to get that forgiven. All right. So this goes for people who have committed some kind of immigration fraud, like misrepresentation. You come into the United States and you come in with somebody else's passport, or somebody, it can't be an American passport, though, I got to tell you that, right? But you come in with another passport from another country and it's not a real passport, it's not in your name. That's a misrepresentation, that's fraud, and you must get that forgiven through a waiver. All right. So there are many ways to get to the promised land. Just do the homework and make sure that you're not moving with people who are trying to get you to be dishonest and break the law. Because when the chips, when the problems come, chances are you are going to be the person dealing with that, not them. So think carefully before you follow the advice of people who want you to do something you should not do. So let me answer questions now. All right, let's see. Teresa said, I want to know what the process is for applying for the adjustment from B1, B2 visa to the employment with the church. What about if the person is an ordained minister from their country and will also get me licensed here? Does that help? So Teresa, the requirements first of all, if you came on a B1, B2, you must be legal status to be able to adjust to an R1. That's number one. Number two, you have to have been a member of that church for at least 2 years. Number three, the church has to be properly designated as a 501c. Number four, they have to be able to pay you for at least 20 hours. So those are some of the requirements, okay? And the church, of course, must want to file for you, okay? So those are some of the requirements. If you have that, then give us a call and let's go through the rest of the process with you, all right? So Shanna Lawrence says, does it matter how long you've been abused? Actually, Shanna, it doesn't. It actually doesn't. So you just have to prove that, like sometimes some people, it's one act of abuse. And for some people, it's a series of little tiny things that together, little droplets of abuse that together form a huge rainfall of abuse, or sometimes, it could just be just little, behaviors of, power and control that, make it difficult for that person to do what they want to do, to be, puts that person in a really bad state, So there's nowhere in the law that says you have to be abused for a certain amount of time. However, there's something in the law that says that the abuse must have happened in the United States, okay? The abuse must have happened in the United States unless the abuser and you were stationed outside because the abuser works for the military or that kind of a government agency. All right. All right. All right, Shanna Lawrence, can't wait to see you. All right. Novi says, when you have a VAWA and I-485 together, do you need to apply for the I-765 to get the work permit? Yes. If you want to work before your VAWA case is approved, you need to file the I-485, I-765. I-765 is a work permit. Okay, but you can't file the I-765 alone. The I-485 is the adjustment of status, and with that, you get to file the I-765. Noelvi says, I did apply for VAWA almost 2 years ago, and you haven't gotten your work permit. That's really strange, Noelvi. That's taken a long time. You should really look into it. Do an inquiry, okay? Yeah, that's really strange. All right. So let me take some questions from because I've been taking questions from Facebook and YouTube. Let me check out my Instagram people. Hey, Instagram people, how are you? All right. Let's go get I said there's a lot of questions on Instagram, but Hello, Mildred. Hello. So somebody says, what's the topic, attorney? Yeah. Do we need to file a police report for complaint? No, you do not. And let's see. With Instagram, you got to scroll up. So somebody says, does it harm the spouse that we loved previously? Does it harm the spouse? No, it does not harm. If you're asking, will your spouse get in trouble because you filed a VAWA that they were abusive? No. VAWA is confidential, and the confidentiality is borne out by the fact that the law recognizes that victims of abuse typically will not report the abuse if they feel that the abuser will get into trouble. Sometimes it's fear of the abuser, or sometimes it's the cycle of abuse where the abuser, the victim actually has feelings for the abuser, right? So no, the abuser is not going to get into trouble because it's not about the abuser, it's about the victim. And the abuser is not going to know. Neither will their job know. None of these places will know because VAWA is confidential, okay? All right, let's see. So someone, Mildred says, I filed VAWA with my two sons that are 20 and 17. Will they from my son who I will above? Gosh, you guys, you gotta read what you're writing. But I think I understand what you're talking about. Your sons were 20 and 17 when you filed the VAWA. You want to know if it will be okay for them because they'll be more than 21 when the VAWA is approved. Yes, it's gonna be fine because you filed before they turn 21. Okay. All right. So let's look at. All right. Let's look at other questions. Someone says, if someone got deported over 24 years, are you allowed back in the U.S. if your U.S. citizen son applies for you? Well, it depends on why they were deported. Some people are deported and can come back. Some people are deported and can never come back. So you want to talk to an attorney and see why they were deported. So I'm going to go to TikTok and answer some questions. Let's see. TikTok. Let's get some questions out here. I went for my interview today. They were told they don't have my file. That actually happens. Isaiah, it actually happens sometimes because if you did a FOIA request, a lot of times, for some reason, I think it's the FOIA people take it, and sometimes you go for your interview and it hasn't been returned. But that happens. So I wouldn't be concerned, but I think what they will do is they'll reschedule you when they get the file back, okay? All right. So Josaifa says, hi, after divorce, I applied I-751 for 3 years ago, and in April 2024, I applied for N-400. What is next? Well, wait for them to call you for the naturalization interview, okay? So the I-751, if you applied for naturalization after 3 years, then I am suspecting that did you apply based on a waiver? Because if you applied for an I-751 based on divorce, you have to wait 5 years before you apply for naturalization. All right. So Ship Shop says, which one is better, applying for the religious visa while outside of the state or inside? Ship Shop, I think it's going to depend on what country you're from. I know that in Nigeria, they're having a lot of difficulties applying for the religious visa from outside. So for them, I guess it would be better if you're inside, but it really depends on what country you're from, okay? All right, let's see. Can a person... So somebody says, can a person get VAWA if they were abused by a family member? It has to be the family member that we talked about, which is a U.S. citizen or green card holder spouse, U.S. citizen or green card holder parent, or U.S. citizen child over the age of 21. All right, those are the only people that you can file VAWA based on abuse. All right. All right. All right. So Joannara says, I'm in an abusive relationship, but my husband is not a U.S. citizen. Can I file for VAWA? No, you cannot. But you may qualify for something else, but definitely not VAWA if your spouse is not a U.S. citizen. Well, Therese, glad that you've come across my page. Come again, okay? So Patience says, when are you going to talk about F1 student visa? Patience, I don't really do F1 student visa, not really. So that's why I don't talk about it. I mean, I know about it, but that's not really where my firm focuses. We focus on U visas, T visas, SJIS, VAWA, deportation, you know, waivers, family-based petition. So, yeah. So somebody had an SJIS question. My grandparents have annual income of 28,000. We live in Sacramento. Is this income for him taking my guardianship for SJIS and the one-bedroom apartment? Is that fine? Paying, it depends on this. The guardianship portion of SJIS is based on family law. So you have to figure out what California is requiring for somebody who wants to be take guardianship in California. In New Jersey, you know, your grandparents could be the guardian. You know, judges don't typically ask about the one bedroom or really about the income. They look at other things. They want to make sure that that child is being taken care of by the person who wants to be their guardian, and that that person can afford to take care of them, has enough money to take care of them. All right. All right. So Emmanuel says, regarding the R1 visa, per your response, what if the applicant who's wishing for R1 is currently not in status? Can you file? No. I think I said that before too. If you're not in legal status, you cannot file R1 visa in the United States, okay? And if you have an inadmissibility, you can file the R1 visa. All right. Let's see. I'm going to answer one more question and then I'm going to head out, guys. All right. So someone says, how long will OPLR take to respond after submitting PD in New York City, VAWA approved? That really depends on the office. You know, some of them answer right away. Some of them will take 6 months. Some of them will take a year. It really depends on the office. So I can't really tell you. We've had various levels of success with New York City OPLA. So sometimes I think it just really depends on the person who's handling the case. All right. Well, guys, thank you for joining me. It was a pleasure. And guess what? I did this live twice this week. So I'm going to try again next week. If you have questions, please go ahead and jot them down on the comment section. I'm going to take a look, and maybe that might form the topic for next week. Okay. Take care. Have a great night.